Hi, I'm firearms attorney Gilbert Ambler, and today we are going to talk about the disingenuous ways that anti-gun lawyers are using a statute that was probably never in effect in the first place out of North Carolina in order to try to support modern gun restrictions across the country. And before we dive into this subject, if you have not yet liked this, like this, subscribe to this, comment below so that we can respond to your thoughts. Share this, that way you and your friends can keep getting this important Second Amendment related content. Now, what we're going to talk about today all comes back to the test articulated in the Bruen case. The Bruen case was decided just over a year ago. That opinion came out in June of 2022. And in that case, the court articulated a legal test for Second Amendment challenges that involved looking at the text, the history, and the tradition. And essentially the test, as a quick refresher, says this: if the law that the government is trying to support today that is being challenged, if that law affects the plain text of the Second Amendment, meaning the law in some way bears upon keeping or bearing arms, then the burden shifts to the government to demonstrate the constitutionality of the law. And they can do that through showing that there is a historical tradition of similar laws in effect in America at or near the time of founding. And to do this, we look at different categories of history, but the most important category of history is laws that were in effect at the time of founding, because they would tell us something about whether the founders believed those restrictions to be constitutional. Here's where this starts to get interesting, because there are relatively few laws that affected firearms and were in effect at the time of the founding. And so there is not a whole lot there for the government to point to when they want to establish a historical analog. Now, of the laws that were around, there have been various repositories. One of the big ones is the Duke Firearms Law Center has created a searchable repository of laws that they purport were in existence at or near the time of founding. And I think you have to ask yourself why Duke wants to have all of these, what motivations they have in terms of why does Duke want to make it very, very easy for the government to find historical restrictions. I would suggest to you that it's possible one of the reasons Duke wants to do that is because the Duke Firearms Law Center might be anti-gun themselves, but check it out yourselves, come to your own conclusion on that. Nonetheless, one of the statutes that Duke has on their website currently is a 1792 statute in North Carolina. And this statute is what we're going to focus on today because it has been referenced in several major cases where the government has used it to say this is a law that can help us support a historical tradition of restrictions on firearms in certain locations. The big cases involving it include the Antonyuk case in New York, the Negrelli case in New York, as well as some district court decisions from Maryland that upheld a restriction on firearms at the National Institute of Health as a sensitive location. So let's talk about this 1792 statute. And to think about this, what we need to think about is the way things worked in 1792, because when the legislature in 1792 passed a statute, it had to literally be hand transcribed. Someone had to write it down. And there was a gentleman named Francis Xavier Martin who was tasked with writing down laws that had been passed in the 1790s in North Carolina. The first thing that drew my attention to this particular statute is that although it is a 1792 statute, it uses the language of the statutes of Northampton from the 1300s in England, meaning it refers to a king. And so the first thing we had to ask ourselves is, why would a statute in 1792, after we had declared and fought for our independence from Great Britain, ban carrying firearms in front of the king? Why would North Carolina care at all in 1792? So that drew our attention to this statute a little bit. And once we started digging into it, what we found was pretty mind-blowing, because the government is using this statute. And again, I can't overstate the importance of this. The government is turning to this statute as one of the main statutes that they are relying on to say, we can still pass restrictions on firearms in sensitive places today. The problem with this statute is that it was likely never in effect. And most tellingly, it was in effect in Sir Francis Martin's 1792 book. It was left out of his 1794 book. So at best, it might have been in effect for 2 years. But when we look further down the road, we see that by the mid-1800s, we see North Carolina courts admonishing the 1792 collection of statutes. In particular, they refer to that collection of statutes and they say that collection of statutes is worthless. They say it is utterly unworth the talents of Mr. Martin because he included statutes that had never been passed and he left out statutes that were passed. Essentially what the court is later saying is that when he compiled the statutes in 1792, he did a poor job and he included things that had never been passed in the first place, which is very likely because why in the world would they pass a statute in 1792 that refers to a king in North Carolina? It just doesn't make any logical sense. This is incredible because if we can show that this statute was never actually in effect in North Carolina, we can take away one of the major tools that the government is using to justify restrictions today on firearms in sensitive places. Because again, a single statute doesn't do it under the Bruen test. They need to be able to establish a historical tradition. So they need to be able to show 3, 4, 5, 6, 7, 8. They need to be able to show that this is something that was widespread understood, a legitimate restriction on firearm laws. And this is one of the big ones that they're using, and I think that they should not be using it because at best it was in effect for 2 years and likely it was never passed in the first place. Share this video, that way gun lawyers dealing with these cases across the nation learn about this nuance, and if they want to reach out, I'm happy to point them to some of the research that we've done and compiled on this subject because we're using it in some of our own cases. And if you have not yet liked and subscribed, please do so. Until next time.